So again, I want to thank you so much for being here for our presentation. We are joined by Craig Ismaili. Craig recently rejoined Disability Rights New Jersey as a supervising attorney, where he oversees a diverse range of federal, state, and administrative litigation. He previously worked at the organization for 3 years as a staff attorney, advocating for clients in Medicaid appeals and developing federal litigation strategies to challenge systemic barriers under the ADA. His prior experience includes working as an associate attorney at Health Law Alliance, as an associate attorney at Giordano, Halleran and Ciesla in the firm's corporate, IP, and healthcare groups. He handled both litigation and transactional matters, including M&A transactions. Craig began his legal career after law school as a litigation fellow with AARP Foundation Litigation, focusing on systemic reform cases affecting older adults. Craig earned his Juris Doctor from Washington University School of Law, where he was a staff editor for the Jurisprudence Review. During law school, he gained extensive public service experience through externships with the WashU Law Appellate Clinic, the National Health Law Program, and the Roderick and Solange MacArthur Justice Center. He is admitted to the New Jersey Bar. Outside of his legal practice, Craig enjoys going to concerts with his wife, Katie, playing with his rescue dog, Jackie, and following the New Jersey Devils in hockey. We do love puppies over here at NJSAP. So Craig, thank you so much for doing this. We really appreciate you coming in and talking about alternatives to guardianship. This is always a fantastic topic, especially talking about supported decision-making. We get lots of questions and interest on that topic. So without further ado, I'm going to turn it over to Craig. Again, Craig, thank you.
Hi, good afternoon, everyone, and thank you for that introduction, Erin. I noticed that you said that you love puppies, but you didn't love the New Jersey Devils over at the Arc, and so no, I'm just kidding. As a Devils fan, it's not going so well this season, so I think, you know, personally, I think maybe I'm more enjoying being with my puppy right now as well. But thank you for joining me for this conversation about alternatives to guardianship in New Jersey. As Erin said, I'm Craig Ismaili, a supervising attorney at Disability Rights New Jersey on our adult practice group. As an initial note, this presentation is not uh, intended to be legal advice specific to individual scenarios or individual clients, but is intended to be a general education for individuals who may not be as knowledgeable in this subject area. If you want specific legal advice specific to your situation, we'll have contact information throughout the presentation, at the end of the presentation, to request services from Disability Rights New Jersey. But you can also contact your own attorney or an attorney in your area as well. So let's get started. I wanted to note also from the beginning that my colleague, Stacy Bussell, who's the managing attorney of our community inclusion team, was supposed to present on this presentation originally and is currently on leave. So I am hopeful to answer your questions fully, but I may need to defer to her subject matter expertise and can get back to you with a response later. So first, I wanted to introduce those who may be unfamiliar to Disability Rights New Jersey. Disability Rights New Jersey is a private nonprofit agency funded with private donations and grants from the federal and state government. And we advocate for the rights of individuals with disabilities throughout the state of New Jersey. We are New Jersey's designated protection and advocacy agency since 1994, which means that as part of that, our mission is to preserve the human, civil, and legal rights of people with disabilities, empowering equality through awareness and expertise. And Disability Rights New Jersey has the federally granted authority to investigate and monitor settings where people with disabilities live, anywhere in the state where people with disabilities live or receive services, in order to prevent abuse and neglect of those individuals. We also provide free legal assistance to individuals with disabilities in a diverse area of practice of law, from abuse and neglect issues to discrimination, issues of voting rights, access to services and supports, employment, education. We have a youth practice group as well that does, they have a juvenile justice project. For clients with issues that don't fall within those priorities, we do also provide information and referral to other legal services providers who can provide legal counsel to them. So our focus for today's presentation is alternatives to guardianship for people with disabilities. And I see in the chat that some people have issues with the sound. I hope the sound is better now that I'm speaking. Just wanted to make sure that I will be monitoring the chat throughout the presentation if you have any questions. But I can also wait till the end if it's something that is a little bit outside of the scope of their presentation. So for today's presentation, the subject is alternatives to guardianship for people with disabilities. In order to fully understand the alternatives to guardianship, we'll first cover what it means to have decision-making capacity and the ability to make decisions for yourself. And then we'll talk about some of the alternatives to guardianship, including formalized supported decision-making agreements and other financial and contractual agreements that can take the place of needing to seek guardianship for an individual who may have some questions as to their capacity to make decisions. And finally, we'll discuss the ways that you can empower people with disabilities in your own life or yourself to make their own decisions, regardless of whether they have full capacity in all areas of life, and to help avoid the application for an unnecessary guardianship, which we feel should be an area of last resort in New Jersey, and it is often not the area of last resort when in practice in terms of how the legal system functions for people with limited capacity. So because both guardianship and its alternatives, including supported decision-making, concern how people make decisions, and whether they have the capacity to do so, let's talk a little bit about how people, regardless of whether or not they have a disability, make decisions. So nearly every person makes at least some decisions every day. Some are small enough you don't have to have input from others at all. You don't have to talk about them with other people, such as deciding what color shirt to wear or dress to wear, or what kind of snack to have in the afternoon. Others are much more complex and might require or benefit from feedback from other people, such as should I take this new job offer or stay at my current job, which is an experience I have had many times in the last year, unfortunately. I'm very, very glad to be back at Disability Rights, but it can be quite a whirlwind to have to make those decisions. It can also be if I live with my partner and share finances, how should we budget our combined incomes? Or what kind of medical care do I want if I become gravely ill and can't decide for myself in that moment? So let's take one example decision and when we might ask for help. Here, like, what do you do if your car you're driving breaks down? How do you decide what to do? If you're not a car person, you may not know what's wrong with your car. In that case, you may call a mechanic to figure out what's wrong and how much it might cost to fix it. You might ask a handy friend or a family member to verify that the mechanic said what the mechanic said, and if they suggested repairs are appropriate and necessary for your car. And if you share your car or your expenses with a partner or your loved ones, you may call them to figure out, can we afford to make the repairs for this car? And even if you're a mechanic yourself, which I'm not personally, and you can figure out what's wrong with your car, you may still want to reach out to other people for support in that decision. You may want to talk to the people you share finances with or get a second opinion from another colleague who is very experienced in this. So in that case, you are certainly going to ask for help in making a decision on what to do with your broken down car, even if it's you in the end that makes the final decision. And this is essentially what we're talking about here is supported decision making. You are asking for support in helping to make a decision. Sometimes even with help, people can make the wrong decision. So they can decide on a course of action without fully understanding all the risks. It could be something like renting an apartment in the nice side of town, but then it happens to be right next to a noisy train line. Or you make a risky investment with a qualified investor and it just doesn't pay off. Even with all the support in the world, people do make mistakes, but they should be allowed to make mistakes and learn from those mistakes. And that's why, what we are really talking about here is one of the key terms in supported decision making is self-determination, which is the ability to determine your own destiny. It's about having the autonomy to set goals for yourself and decide how you're going to achieve them. This means taking ownership of your actions and choices, which is often empowering. It also means that an individual must make a decision entirely on their own. Doesn't necessarily mean that. It means that you can make a decision on your own, But you can also have input from others. You can have family, friends, or trusted professionals can be an invaluable part of a decision-making process. But it means that you essentially have the ability to make that decision without someone overruling your decision. And it's key to remember that developing these skills takes a lot of time for everyone, regardless of their background or abilities. Learning how to make effective decisions uh, and the right decision confidently is a gradual process. So next, the other key term that is often discussed when you're talking about guardianship or other types of decision-making authority is the word capacity. And so what does it mean when we say that someone does or does not have the capacity to make their own decisions? So when we talk about capacity, what we're often saying is whether is not about whether a person's decisions are responsible or correct, but whether they have the ability to make the responsible decision in the first place. So the focus is not on the individual's ability to understand their choices. The focus is on the individual's ability to understand their choices and the consequences of those choices, not whether they make the right decision every time. In legal terms, adults are presumed to legally be competent to make their own decision unless a court has adjudicated them as incapacitated. So unless a judge has established a guardianship that the person has a legal right to make decisions in all areas of their life. Just like you are innocent until proven guilty in a court of law in a criminal matter, you have the capacity to make your own decisions unless you're proven otherwise by the courts. It's also critical to recognize that while there is a legal definition of capacity when it comes to guardianships, which we will discuss shortly, there is no one size fits all definition of what capacity means. It can be a nuanced concept that depends on the individual and the situation, and that's why oftentimes courts have a really hard time sorting out whether someone has capacity or not based on certifications and evaluations from even doctors and treating physicians of that individual. Additionally, sometimes a person may have capacity to make one kind of decision, but not have the capacity to make other kinds of decisions, and that can also complicate matters. So just as there are different levels of capacity, as I was just talking about, there are also different models of decision making. So up on the screen here is an arrow pointing from left to right with 4 colored dots. The first of the dots from left to right are gray and they're labeled independent, supported, and surrogate. The last blue dot is labeled substitute, and we'll refer back to this arrow later on throughout the presentation. But if you're looking at deciding from the perspective of who is the decider, you will see that these things start to line up in a spectrum. The more input from other people matters, the further from an independent decision making we go. So from left to right. In surrogate decision making, so on the left, independent and supported decision making, the person who is the subject of the decision is the ultimate decider. In surrogate decision making, it's when someone else besides the subject of the decision decides the decision. So they make a decision based on the person's values and documented wishes, but they make the decision on the person's behalf. Sometimes you might be able to overrule the surrogate decision maker, but it's not always the case. And it's like someone is standing in for you as a surrogate. So we'll talk more about what it means when someone has a surrogate decision-making authority over an individual. And then finally, if we move to the last dot on the arrow, a substitute decision maker makes decisions for you based on what the substitute decision maker thinks is best for you. They might apply objective standards like the quote best interest test, but they may consider your wishes as well. But in all situations, when there is a substitute decision maker authority, that substitute decision maker decides, not the subject of the decision. Substitute decision-making schemes are things like guardianship. It's the most common example of a substitute decision maker. And this is why we consider full guardianships to be the most restrictive decision-making mechanism, as the person who is the subject of all the decisions has no control over the decisions in their lives. Now that we've completed the discussion about decision-making generally, let's talk specifically about guardianship. So if you're in the disability rights world like I am, you probably know some things about guardianship. So we'll do a quick quiz. I'll put up a statement about guardianships, and you can tell me whether you think it's true or false. You can say it in the chat, or you can just think it in your head. And so first up, the question, the statement, every person with a cognitive impairment needs a guardian. The answer is false. Not every individual with a cognitive impairment requires guardianship. Many people with cognitive impairments can make decisions for themselves with the right support and accommodations, which is why alternatives like supported decision making should always be considered first for people with cognitive impairments. Next, in order to get medical information about a family member with a disability, family members need to have guardianship. Again, this is false. Guardianship is not required for family members to receive medical information. Family members can often access this information through other legal means, such as healthcare processes or power of attorneys or a designated healthcare representative form, and even just having the individual sign a release of information to allow the healthcare provider to share information with them without needing a legal guardian to be approved in order to get that information. Next statement, a guardianship lasts only as long as the guardian's lifespan. This is also false. Guardianship is based on whether the person subject to the guardianship has capacity to make decisions, not based on the lifespan of any of the guardian appointed. In the absence of evidence that the person subject to guardianship has regained capacity, the person continues to be subject to a guardianship, and if the guardian passes away, the court will appoint a new guardian to take over their responsibilities. And the court often does appoint a new guardian, even when the old guardian passes away. A guardianship is a deprivation of a person's legal rights. So you might have thought it was a pattern, but this one is actually true. Guardianship does limit or deprive a person's legal rights in many areas. Even if the person benefits from a guardianship, they are still depriving themselves of some of the rights that they are entitled to as a citizen. A guardian makes decisions on behalf of individuals in areas where the courts have determined they lack the capacity to make decisions independently. That's why I will say this over and over again in this presentation, but we do strongly feel as an organization at Disability Rights that guardianship should be viewed as a last resort after exploring all other alternatives to preserve an individual's autonomy to make their own decisions. So now that we've warmed up with that little quiz, we'll talk about what a guardianship is. So guardianship is a legal structure that allows a court-appointed individual to make decisions on behalf of another person. This person is often usually considered to be the person subject to guardianship in the literature. The old-timey word ward is sometimes used, but it's much less frequently used now. And yeah, person to subject to guardianship, while it is wordy, is the terminology that is often used now. This means the guardian is given the authority to make certain decisions when the individual is deemed to lack the capacity to make those decisions on their own. And again, the person challenging the other person's capacity has the burden of proving specific incapacity by clear and convincing evidence in a court of law. And that is what we were talking about before, that the judge needs to approve a guardianship. There are different types of guardianships depending on the areas of the decision-making authority that is being challenged in the matter. So there is guardianship of the person, which is a type of guardianship that appoints a guardian to manage the personal affairs, such as healthcare decisions, living arrangements, and personal well-beings of an individual. There's also guardianship of the estate, which is where the guardian is responsible for managing a person's financial affairs, such as their assets, their income, or their property. And then there's guardianships of person and estate, or guardianships of everything, which is a guardian is given full responsibility for a person's personal and financial affairs, and they handle all decisions in the individual's life. So in New Jersey, the standard for guardianship is incapacity, which, as I said before, is defined as an individual who's impaired by reason of mental illness or intellectual disability to the extent that the individual lacks sufficient capacity to govern himself and manage his affairs. This definition, as you can see, is a little bit circular. You are in New Jersey, you are incapacitated if you lack capacity, essentially, under the language of the law. But the key language here is to govern himself and manage his affairs. And in addition to being uh, in addition to being there are different types of guardianship, whether it's person or estate, you can also have different scopes of guardianship, from general guardianships, which grant the guardian full authority to exercise all rights and powers of the incapacitated person. And the guardian, in that case, would make all major decisions on behalf of the incapacitated individual. But then there's also limited guardianships, which can be more context specific. They can apply when an individual is deemed by the court to lack capacity to perform certain life tasks, but not all. For example, someone may still be able to make some decisions independently, like their medical decisions, but they may not be able to make more complex decisions like their finances. And so in those cases, the court may appoint a limited guardian who is responsible only for that specific area. And that the court will then, in those cases, make detailed findings about which tasks the person retains the capacity to manage and which areas require the support of a guardian. So, despite the availability of limited guardianships as a less restrictive pathway than a full or general guardianship, applicants seeking guardianship over an individual and subsequently courts often default to a full guardianship, a general guardianship, even where it is not necessary. As a result, individuals can end up with unnecessary restrictions on all aspects of their lives, even when they are able to tolerate a limited guardianship and still be able to maintain a lot of decision-making authority. Even so, if there's basically a showing of any incapacity, then it is applied to all their decisions, and a general guardianship is appointed. So going back to our spectrum of decision-making, our continuum here, guardianships, as I said, fall under the substitute decision-making, which is the most restrictive form of decision-making, wherein other persons make decisions on your behalf. And guardianship in New Jersey is subject to a process governed by Court Rule 486-2. So a petition for guardianship must include affidavits or certifications from two physicians, or one physician and one licensed practicing psychologist. And these medical professionals, are asked to provide their opinion on the extent to which the alleged incapacitated person is unfit to govern themselves and manage their affairs, and assess whether the individual retains any capacity to manage specific areas of their lives. And when seeking guardianship over an individual who is eligible for services under DDD, the documentation becomes a little bit different, and the specific requirements change when the individual is eligible for or currently receiving services from DDD. And we won't go over the requirements in detail due to the time limits today, but I have them on screen here, and just want you to know that the process is a little bit different if the alleged incapacitated person is DDD eligible. So under the New Jersey court rules, individuals subject to guardianship do retain several important legal rights, even if a guardian is appointed to make decisions on their behalf. These rights are meant to ensure that the person is treated fairly and with dignity, even when they are subject to a guardianship. It's also really intended to protect the autonomy of the person, which is under a tremendous amount of risk in a guardianship framework. So you see there the list of rights on the screen, and these, in reality, I don't know how often these are enforced with legal challenges, but they are, knowing and reminding others of these rights plays a key role in helping to encourage self-determination, even for an individual who is subject to guardianship, and helping to protect individuals from unnecessary guardianship. So you see there, especially the rights to personal info kept confidential, the right to communicate privately with an attorney or another advocate. That is an attorney of the person with incapacities decision, own determination, not a attorney selected for them by the guardian. That is a very important right, obviously, because you want to make sure that the attorney-client communications are kept confidential and not subject to the guardian's oversight, especially in a case where someone who is subject to guardianship may want to challenge that. You don't want to have a situation where an attorney is selected for them by the guardian that they are seeking to have removed. And so that, again, like that right to petition the court to modify or terminate a guardianship and the right to meet privately with an attorney to advocate or assist with this legal process is really important, and it needs to be enforced by the courts and by the case law. So speaking of the case law, let's take a quick look at some of the important case law that further protects the rights of individuals subject to guardianship. So you'll hear about this case a lot if you are an advocate for people with disabilities and a advocate in the space of trying to remove unnecessary guardianships. The big case here is in re MR, or in the matter of MR, which it was a case from 1994 in the New Jersey Supreme Court that ruled general incompetence does not automatically mean an individual is incompetent for all purposes. This case reinforced that a person under guardianship is still able to retain the ability to make decisions about specific aspects of their life, such as choosing where they want to live and making personal choices, as long as they have the capacity in those specific areas. It's crucial, again, to note that guardianship does not remove a person's ability to choose where they want to live. Even under guardianship, an individual still has the right to make decisions about their residence, ensuring that their living arrangements ally with their preferences whenever possible. In practice, as a disability advocate, I can tell you that is not often treated that way by the courts, and that's why it is really important to try to highlight to the extent possible that guardianships can be overreaching, and that the case law supports that even people subject to guardianship should be able to make their own decisions to the maximum extent possible. So again, going to the court rules here, an individual subject to guardianship or an interested person on their behalf has the right to file a new court action to seek the return of full or partial capacity. This means that the person believes they no longer need guardianship or have regained the ability to make certain decisions, and they can request that the court modify or end the guardianship. When filing this complaint, it must be accompanied by at least one affidavit from a physician or a psychologist, which is one fewer that obviously than is needed when the initial filing occurs to grant guardianship. But that is a good thing because it is often very difficult to afford an independent assessment when you are subject to guardianship, as we have found. Luckily, disability rights has been able to retain physicians for certifications for clients of ours in the past, but it can be difficult for people individually to retain a psychologist or a physician to be able to write a report to challenge their guardianship that they are subject to. And this affidavit should explain that the person is no longer incapacitated and has regained partial capacity in areas where they previously needed support. So there is no separate rule for individuals who are eligible or receiving services from DDD to terminate a guardianship, unlike there is with the filing for guardianship. The process remains the same for any individual seeking to retain their rights. And again, under the New Jersey court rules, the person subject to guardianship can seek a review of the guardian's conduct or request a review of the guardianship itself. They can do either, they can do both. This is done by filing a motion with the court that sets forth the facts and jurisdiction for the review. And this process ensures that guardianship remains appropriate and that guardians are acting in the best interest of the individual subject to a guardianship at all times. So under New Jersey court rules, the authority and responsibility of a guardian will terminate under one of the following circumstances. As we said before, death does not terminate the guardianship, but it does terminate the guardian from and then a new guardian would need to be appointed. But if the guardian dies, resigns, or is removed from their role, the authority to act on behalf of the individual ends. In such cases, the court may elect to appoint a new guardian. Death of the person subject to guardianship. If the individual under the guardianship passes away, the guardian's responsibilities are automatically terminated, and the need for a guardianship ceases with the death of the individual. And then finally, entry of judgment adjudicating the restoration of capacity or competency. Or the termination of guardianship for other reasons. That's what we just discussed, the ability to have the individual make a petition that they regain the capacity to make their own decisions, or the court can independently terminate a guardianship after careful review. But what we have seen is that this is a difficult court battle from our experience to get courts to restore capacity, and it is very infrequently done. So now I wanted to address what guardianship is not, which can be a helpful tool to understand why we consider it to be a last resort at Disability Rights New Jersey. Legally, a guardianship does not give absolute control, even in a general guardianship, and that's very commonly misunderstood in New Jersey. When an individual is determined to be incapacitated, that does not mean that all of their rights are removed. The guardianship statute requires guardians to give due regard to the preferences of the incapacitated person. So a guardianship is not absolute control or removal of all rights. It's not an all-seeing, all-knowing person who knows what's best for the individual. It's not a magic wand that will make everything perfect and give the person the ability to find housing or all the medical decisions that are needed. It's guardianship is not a magic wand that will wave away all the problems of the person subject to the guardianship. It's also, as I said before, not easy to undo. It's not something that it's not. It's really just it's a thing where if a court finds an individual to be incapacitated, it is a very difficult thing for the court to reverse their decision. And judges in New Jersey are very diverse in their beliefs, but they are very hesitant to restore someone to capacity, even if the guardian is the person seeking the restoration of capacity. And so when there's a conflict, or even where everyone is in agreement that the guardianship can and should be dissolved, it can still cost a tremendous amount of money in legal fees, but also or Disability Rights New Jersey or another legal services organization taking the case, or it can take a very long time, sometimes several years, to get a guardianship restoration calendared and get through a contested guardianship action to be able to then have the judge restore the capacity. And without an order, someone found to be incapacitated will maintain that guardianship status. So it is not just an easy, send a petition to the court and you can regain your capacity. It is often a very long, drawn out legal process. And then the last thing to note is that the thing about guardianship is that it's also not a publicly announced, very public, legal document that states this. It's a private physical restraint that comes to an individual. People with guardians you're not going to have a scarlet letter that says that you are subject to a guardian, but it will be something that privately makes your life much more complicated, and it changes the way that you interact with the world and the way that you can interact with your community, especially if you're living in an institutional setting and subject to a guardianship. It can make it very difficult for you to have the autonomy to make decisions on your own behalf. So now we're going to be moving to our third learning objective here, which we want to spend a good amount of time discussing less restrictive alternatives to guardianship. So really what the presentation we're trying to discuss here is, obviously we know that guardianship can often be viewed as a necessary evil by people that are seeking guardianship of a loved one. But what we really want to talk about is getting across to people that there are many less restrictive alternatives to guardianship to explore before taking that step, that necessary evil to seek guardianship of a loved one. And so one common alternative to use is other legal documents or tools in which an individual can name someone else to make certain decisions or assist with their decision making. These can, again, also be general or limited, specific to specific areas, depending on the specific needs of the individual. So here we have a list on the screen of different less restrictive alternatives to guardianship. Many of these are formalized legal documents, such as a supported decision-making agreement, a advanced directive or a living will, healthcare proxies, psychiatric advance directives, medical orders such as do not resuscitate, do not hospitalize, do not intubate, which are all these DNR, DNH, and DNI acronyms there, or a POST agreement, which is a physician's orders on life-sustaining treatment. These are all medical orders that you can give to set out your yes, I will share the slides, by the way, just to see that in the chat there. I will make sure these slides are sent around as well. But these are medical decision-making agreements that can help others know what your decision is on something that is important to you in your healthcare decision-making before this comes up in case you are incapacitated later. You also have powers of attorney agreements or representative payee agreements for individuals that receive SSI or SSDI from the Social Security Administration. And you also can have agreement to have joint ownership of bank accounts or other property that allow some other decision-making capacity to be shared between you and loved ones. So these tools we're talking about here are, may only take effect if and when the person becomes incapacitated. They may be springing, which means that essentially they are not in effect until the person is determined to have a lack of capacity to make decisions, and allows them to continue making decisions independently until assistance is needed. The issue a lot of times that we see is that guardianship is sought preemptively before capacity can be fully like someone could be determined to fully have lost capacity, and you may have, a limited guardianship that is unnecessary, before someone is really, unable to make decisions for themselves, or you may have a sort of protective idea of what someone's decision-making authority can be, and so you have, a movement towards guardianship that is unnecessary when other alternatives could be put in place that would be less restrictive and still make it so that the person can make the best decision for themselves. So the next thing I wanted to just discuss here real quick is there are a lot of other specific tools, context specific for people subject to, that are seeking different services to be able to get those services without having to have a guardianship appointed. What we have heard from in my casework is that a lot of times it's well-meaning in terms of when or how a guardianship application is initially submitted. It's, we're being told that you need to have this guardianship in order to file for Medicaid or file for vocational rehab services for the individual. And then, now you have this court order that appoints guardianship when there are other ways to seek those services without needing to go to the courts and get a guardianship of an individual. So, there's designated representative documents, which are a useful tool for accessing services. You don't need to have a guardian in order to have someone help you with your Medicaid application, which is something, again, that I've heard very frequently from people who seek guardianship, that they were told they needed to get guardianship in order to help them apply for Medicaid. This can happen in a context of, especially the times that I've heard of it, it's in institutional settings like nursing facilities or developmental centers. I've heard of people seeking guardianship in order to qualify for Medicaid benefits. It's also important to discuss the possibility of releases of information, which are, especially in the healthcare context, very important because people are skeptical about giving out legal documentation, as I said before, because of HIPAA protections and other privacy protections in the healthcare space. Getting releases of information for your loved ones so that you can continue to access all important and vital documentation and information. There's also transition age supports So, there are a lot of tools and supports available to people with disabilities who are of transition age, and transitioning from school to adult services. And there are a lot of different resources available to help allay concerns for family members, as the person with a disability explores work options, including job coaching that's available through DVRS or pre-employment transition services, which include job exploration or assistance with applications. This is not an area that I personally am very particularly familiar with, but I can point any questions or concerns regarding these services to my team for further discussion. And for people with disabilities where the right to decide can be questioned by third parties, sometimes having a supported decision-making agreement can help overcome these obstacles. So these supported decision-making agreements are a process by which individuals receive help from trusted people in their lives, like family, friends, or natural supports to make decisions. And the support might come from professionals such as social service agencies, caseworkers, physicians, or social workers, or it may come from loved ones and family members and friends. And some states have laws specifically about supported decision making, which help formalize this process. Unfortunately, New Jersey does not have such specific legislation about supported decision making at this time. However, even without these laws in place, people in New Jersey can still use model forms to help create a supported decision-making agreement. These agreements are very useful because they can be presented in court in a less restrictive alternative, as a less restrictive alternative to guardianship. And they show that the individual can make their own decisions with the right support, helping to preserve their autonomy while ensuring that they have any assistance they may need to make the right decision for them. And you can craft your supported decision-making agreement however works best for you. That being said, there are a few fundamental elements. As an attorney, I should recommend that these elements are considered and included in any supported decision-making agreement. First, the subject of the agreement should define who will ultimately be responsible for deciding and write it down very clearly. And the decider should always be the subject of the agreement themselves. And writing this down helps to remind everyone else what the subject of the agreement says goes. And so the decider also should have the power to change this document at any time for any reason, including removing or replacing different supporters. Second, it's important to define the supporters. It helps to be as specific as possible for each supporter and how they're involved in helping the decider come to a decision. And so I see there's questions in the chat here. Is there an emergency option under any category that is best to use when it has to do with siblings? Example, death of parents and nothing was set up for adult sibling with disabilities. And would it be suggested to have language in a living will or trust that enforces that we want the least restrictive supports? So I can address these as soon as I'm done with the presentation. But yes, I think having suggested like language in a living will or trust that enforces the choice of a least restrictive support, so something like a supported decision-making agreement. You can incorporate a supported decision-making agreement that is sprung upon a life condition. So that can be part of a living will to say, if it works for now that you have your family supporting you in your decisions, but say your parents were to pass away, or a loved one would pass away, then this living will would indicate that this decision-making agreement would go into effect, the supported decision-making agreement would go into effect, and these would be the deciders, these would be the supporters. Rather than preventing the seeking of an unnecessary guardianship for a disabled individual. And so I just want to show this on the screen. On the screen are several experts from sample supported decision-making agreements, which we can include in the slides that are prepared, that are sent over. And in the context of decision-making, that it's really important to kind of go through what this would look like for you as an individual seeking to draft a supported decision-making agreement with your loved ones and your friends. Next up, we wanted to kind of just quickly talk about surrogate decision making. And I see we have a few Q&As in the chat that I will make sure I get to at the end as well. I'm seeing now. So surrogate decision making is when someone steps in to make decisions on the behalf of another person. Um, and then just to quickly go through some of the other alternatives to guardianship, there are advanced directives, as I talked about before, which is a legal document where individuals outline their preferences for medical treatment if they become unable to communicate those preferences themselves directly, and it ensures that their wishes are respected even when they can't speak for themselves. So things like proxy directives, which are or also called healthcare proxies or durable power of attorneys for healthcare, and it appoints someone, usually a trusted family member or friend, to make healthcare decisions on behalf of the individual if they were to become incapacitated. There's also instruction directives, which I know we just discussed in the chat as well, in terms of a living will, which is, or like it's sometimes called a living will, which is a document that allows individuals to provide specific instructions about the types of treatments that they want, even if they become incapacitated later. Um, and then there's also another form of a sort of surrogate decision-making agreement is a representative payee agreement, which is a when a person or organization is designated to manage someone's Social Security benefits if the individual is unable to do so themselves. The representative payee ensures that the benefits are used for the individual's needs and they are held accountable for the proper use of those individuals' funds. So individuals um, are held accountable if they misuse funds or there's any fraud or conflict of interest in the management of the person's SSI funds. Um, then quickly, just to go through another surrogate decision-making agreement is a power of attorney, which allows an individual to grant someone else the legal authority to make decisions on their behalf in specific areas, such as financial or legal matters. And it can be a limited power of attorney or a durable power of attorney, meaning it can remain in effect even if the person later becomes incapacitated. And these surrogate decision-making tools provide a way for individuals to ensure their preferences are followed, even after a court would determine them to lack capacity to make their own decisions. Um, and so finally, we're going to talk about what you can do starting right now to promote self-determination for people with disabilities, including yourself and your family members. So one of the things you can really, like I will kind of keep reiterating here is to really think about what it means to exhibit self-determination. And your family member or your loved one should be leading their own meetings and be at the center of all discussions. Direct questions from others that your family member can answer to the best of their abilities. Do your best to let your family member always decide. And even where a person expresses indecision, that doesn't mean that they lack capacity. It just means that they need help getting to their final decision. And it doesn't mean that that you should seek a guardianship just because they are unable right now to make a decision for themselves. They may at any point regain the ability, and it'd be really difficult to walk back a guardianship petition after it is filed. And so really thinking about whether it's best to file for an unnecessary guardianship. Um, and so the other thing you can really do is know your family members' rights and push back on providers or other individuals who tell you or a family member that you need to have guardianship in order to be involved in their care, and make sure you're expressing and being conscious of their right to and the risk to the individual if a guardianship is appointed for the individual. Um, and and I think that is, I can get into the Q&As. I see there's a lot of questions in the chat, but remember, you can always contact Disability Rights New Jersey for more information or refer a client to us for assistance with transition or unnecessary guardianship and other rights. I thank you very much for your time. I know I didn't leave a lot of time for questions, but I know we can get to the chat here. I see there's about 6 or 7 questions in the Q&A as well that I can discuss here.
So just to address for the slides, everybody will get an email that goes out with the slides, and then they will also be available on our website.
So just to quickly go through, I know Jill Sigulin in the chat and the Q&A asked a question that said, is guardianship permanent, or can a person subject to guardianship have this revoked? through themselves or another person. And I know I talked about this in the presentation, but I just want to reiterate, guardianship is not permanent. It can be revoked by a court petition. You can seek to restore your capacity to make your decisions, or someone else can seek to have your capacity restored on your behalf. In practice, it is, I think, rare for a guardianship to be dissolved because of restoration of capacity, but it does happen. According to my NJDDD, so this is Landone in the chat, says, according to my NJDDD's fiscal intermediary, when you are a hired self-directed employee, you cannot also serve as an authorized representative to manage the day-to-day operations of the person's DDD budget, including hiring, training, and supervising staff. But what happens when the hired self-directed employee is also a legal guardian for a person and estate? Would the fiscal intermediary have to make an exception to allow the hired self-directed employee to serve as an authorized representative? I think there would be a conflict of interest there if the hired self-directed employee is a legal guardianship for the person. That would be, I think that would not be authorizable under DDD. I'm not entirely sure on that, but I can find more information out. But I think that would be immediately to me flagged as something that would be a conflict of interest, and they would probably want to seek an independent legal guardian. Walter, yes, which I've spoken to this week, said that thanks for an excellent presentation. I'm looking forward to working with you to bring New Jersey into the 21st century. And yes, as I said during the presentation, supported decision making is not in New Jersey statute, and hopefully we are headed that way to become, as Walter indicated, the 24th state to have supported decision making in legislation on the state level, and hopefully that does become the case. Having more clarity and more guidance from state legislatures as to how these agreements should function and the protections in place for individuals subject to a supported decision-making agreement would be very helpful, and it would be helpful to be able to give guidance and feedback on how to create these supported decision-making agreements if there was legislation to indicate New Jersey's preferred form of these agreements and what courts can then enforce in terms of these agreements. You said when a guardian is no longer alive, the guardianship is ended. So that is not, if I did say that, then I apologize. That's not exactly true. The guardian, if the guardianship of the person by that guardian is then ended, the guardianship would continue even upon the death of the guardian. So if it's a partial guardianship, so I'm just going to answer live just so that this is on the screen. If it's a partial guardianship, say over the estate and finances, do the decisions then go to the state or the person who is under guardianship at that point? So if you are subject to guardianship and your guardian passes away, the court then would be tasked with appointing a new guardian. And even if it's a partial guardianship or a full guardianship, the court would then, you could have a situation where at that point, the person subject to the guardianship could petition the court to restore their capacity and not appoint a new guardian at all. Or the court could appoint either another individual who has interest, like a family member or friend who could serve as the new guardian, or if no suitable guardian can be found by the court, then the court would then appoint a state guardian for the individual, and they would be subject to guardianship by the state guardian in that case. Is it difficult to change from limited guardianship or power of attorney or other supported decision making? Yes. I think this is another, Lisa Pinkerton said this in the chat. It is difficult to change from a limited guardianship to a different kind of less restrictive alternative that you would then need to, even with the limited guardianship, you still need to petition the court in order to restore the capacity of the person subject to a limited guardianship before then you could have a power of attorney or other supported decision-making agreement go into effect. And that's why it's so important to think of guardianship as the option of last resort rather than we'll get guardianship and then figure it out later, because it can be very difficult to unwind a guardianship even when the person with the guardian is seeking the guardian to have the guardianship revoked, it can be difficult. So it is important to explore less restrictive alternatives first, such as a power of attorney, or even better, a supported decision-making agreement, because power of attorney again is a surrogate decision-maker authority, versus a supported decision-making would be a supported decision-making authority, and that would help the person who has questions as to their capacity retain the ability to make decisions on their behalf. And this is always one of those ones that so there's one more question in the chat here. The difference between a guardianship and conservatorship. I think the terminology is used, it can be sort of unclear across states, but let me try to just kind of get a quick sense of how to best describe this. But it can vary based on the state, but let's see. So conservatorship is really limited primarily, I think, to financial affairs and assets and property, versus guardianship can handle both the financial and personal. It's not a very helpful distinction, and but the terminology is often used interchangeably in the law. But I don't think I did a very good job of explaining what the difference is, but hopefully someone else in the chat can assist.
There's a few more questions as well. We have Jessica asked, is there an emergency option under any category that is best to use when it has to do with siblings? Example, death of both parents and nothing was set up for adult sibling with disabilities.
Well, I would encourage you to explore supported decision making as a possibility. Supported decision making agreement where your loved one would be the ultimate decider, but then you as siblings can be the supporters in that decision making agreement. I know I can go back to the slides on that and just have them up on screen as I'm talking about this. But having an agreement that is speaking to the specifics of the scenario here, where there is not currently, the parents are not in, parents have passed away and they're not able to assist the sibling with their decisions anymore, but the sibling still wants some family support in their decisions. And so having an agreement in place where the sibling still has the ability to make their own decisions, but they have this structured ability to be able to make decisions with their brother and sister involved in the decision, and exactly how that process would work for your sibling. I think exploring that as an alternative to seeking guardianship or power of attorney for that person definitely, I think, sounds like, even where it may be sort of an unexpected loss, it's still helpful to think about how to avoid the more restrictive options where possible. Was there any other questions? I think there was.
Yeah, Shanice asked, would it be suggested to have language in a living will or trust that enforces that we want the least restrictive supports that prevents family members from seeking legal guardianship, etc., of a disabled individual?
Yeah, I think I maybe mentioned this before when this question initially. So I do think it would be smart to either have language in a living will that speaks to these this kind of structure, or just to have a separate agreement entirely, that then would be ironclad documentation of these restrictive support. These don't need to be part of a living will or a trust in order to be enforceable. Supported decision makings can be enforced by the court. I see that audio is breaking up again, and I apologize if you are unable to hear me, but it would be wise if you want to make sure that your rights are protected in the future, because living wills go into effect when someone becomes incapacitated, and those living wills or trusts. So trusts are a little different, but living wills would only go into effect if there is a later showing of incapacitation for the healthcare decision. And so having these agreements in place, supported decision-making agreements, can help both before and after this determination of capacity is made. And so it's just another tool in the toolbox, along with living wills, along with the power of attorneys, along with uh, all those different types of contracts that we showed on screen, the proxy directives, the Pulse, the representative payee agreements, all these different types of agreements that are legal documentation of a person's wishes that are not as drastic and dire a deprivation of a person's rights as guardianship.
Excellent. So if you have any more questions, you can absolutely reach out to DRNJ, especially if you have very specific questions on your situation. But I just want to thank everybody for being here. Craig, thank you so much for this. We are huge proponents of SD supported decision making, and we can't wait until that is also a legal option in New Jersey. So thank you so much. I really appreciate it. And I hope everybody has a fantastic rest of your, what day is it? Tuesday.
Thank you
Thank
so
you
much
all
for
so
having me,
much.
Aaron. Thank you.